All rise. The Court of Appeals, Division 1, internal session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1 CACV 180616, E&M Services versus A&N Services. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients. At the beginning of your argument, each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of time for rebuttal if desired. Also, we've read the briefs and have discussed this case in conference. Counsel, you may proceed.
May it please the court. I'm Matthew Ralph of Dorsey & Whitney on behalf of appellants here, defendants below, A&N Services, and Ned and Abed Lawabni. I'd like to reserve 3 minutes of my time for rebuttal. This appeal presents 4 substantive issues. 3 relate to the district court's denial of A&N's counterclaims. 1 relates to its findings on E&M's fraud claims. I'm going to begin with E&M's fraud claims.
Before we get started, counsel, let's just make sure that I understand. Your client is not contesting the payout withheld from rides from July 11th, 2016 to August 22nd, 2016 of $86,412.70?
That's correct, Your Honor.
And also the erroneous recoupment of the mailboy ride?
That's correct, Your Honor.
And additionally, the Office of Inspector General related chargeback of $1,866.27?
That's correct, Your Honor.
Missing rides from 2015 and 2016 admitted that they owed them?
Correct.
And the underpayment from 2014?
That's correct, Your Honor.
Excellent. Okay. I just wanted to make sure we were on the same page. We've got 4 things we're going to deal with. Please proceed.
And just to clarify, the underpayments you listed were all of E&M's claims in the case. We're not contesting those. We disagree with the results. However, we think the district court acted within the scope of its discretion in those awards. So we're only talking here today about 3 counterclaims and the fraud finding. The economic loss rule should have barred E&M's fraud claims. E&M suffered only economic losses in the form of contractual underpayments. There was no policy reason to apply tort liability. There was no physical injury to persons or other property. Under the Supreme Court's decision in Flagstaff and this court's decision in Cook, the economic loss rule should have barred the fraud claims. But the district court applied the wrong rule. In ruling on A&N's motion to dismiss, it ruled that it would hear evidence to determine whether, quote, plaintiff's contract claims predominate over the fraud claims. And that's not the correct test for applying the economic loss rule. And there was significance to that ruling because the district court at trial reached a number of findings that were irrelevant to a contractual analysis. The district court decided that A&N acted with fraudulent intent, something that's irrelevant to a contract analysis. There was no reason for the district court to find, as it did.
Counsel, you mean the Superior Court?
Yes, the Superior Court.
Okay.
Sorry. There's no reason for the Superior Court to find that A&N was caught in the act of wrongdoing, as it did on pages 6 and 10 of its order. And there was no reason for the Superior Court to find that A&N engaged in inappropriate counting, as it did on pages 2, 4, 5, and 13.
So when you say no reason for the Superior Court to find, was the Superior Court precluded from finding?
Your Honor, I think under the correct analysis, all of that extraneous information, there was not only was there no reason to reach it, but if the district court had been more careful, it would have concluded that the actual evidence was insufficient to support those findings. Fraud requires clear and convincing evidence. And in this case, the fraud finding was based on the 2014 alleged alterations of the payout reports. In that particular instance, A&N gave a very clear and coherent explanation for what happened. It basically said that it deducted denied claims from those rides. Now, it didn't have any documentation to support that, but that's certainly a reasonable explanation for why.
But wasn't the trial court free to believe or disbelieve?
Yes,
the explanation?
It was, Your Honor, and that's why we don't challenge that finding on appeal. But the point as it relates to the fraud claims is that clear and convincing evidence has to support fraud claims. And
so
in this case,
how do we know that that clear and convincing evidence didn't support his finding of fraud? Where in the record do you find that missing?
Well, I would contend, Your Honor, I mean, when you weigh the evidence, one party alleges here's an alteration, and the other party says, well, here's the explanation for the alteration, and it's a perfectly reasonable alteration or explanation that's consistent with all the facts.
But what if the trial court decides that it's not a reasonable explanation and just makes credibility determination that he doesn't believe the explanation that's offered? Would there be clear and convincing evidence that would support a fraud?
No, Your Honor, I don't think so, because here what you're talking about is the reasons why you reject the explanation, and you can't use the rejection of A&N's testimony as a basis for assuming there's some positive opposite evidence in favor of the plaintiff's testimony. Well, if you search the record in this case, all of the evidence, so-called evidence of the wrongdoing and fraud, is almost exclusively the testimony of the plaintiff, and he didn't have a foundation for most of that testimony. In particular.
So what are you asking us to do exactly? This isn't, the trial court made certain rulings based on his evaluation of the credibility of witnesses. Agreed?
Correct.
Our job is not to reweigh that evidence, but to accept his determination. Would you agree?
I disagree, Your Honor. I believe that
Explain.
this court is required to weigh the evidence. So let me turn now to the A&N's counterclaim related to loan repayment, because that will explain more concretely what we're asking the court to do. In respect to the fraud claims, we think there was error to include findings in those. We think those findings should be stricken. We think it affected the entire analysis. But it will be more concrete if I discuss the other claims where there's actual dollar amounts at stake. Now, on the loan repayment claim, E&M asserted an affirmative defense to A&N's loan repayment claim. E&M, the plaintiff, therefore bore the burden to prove repayments by 51% preponderance of the evidence. But the district court failed to the district court faulted A&N, the party without the burden of proof, for the lack of evidence of repayment. On page 4, the district court wrote, A&N, my client, testified that Eslam never repaid any of the loans, but A&N's written evidence is woefully lacking. In other words, we're supposed to prove the negative by submitting evidence. Specifically, the court found there were no promissory notes, but that isn't really relevant to the issue of repayment. That only goes to the issue of obligation, which it was uncontested that they had an obligation to repay them. The district court found, well, there are no emails or other documents indicating a payment schedule. That's evidence that he held against A&N. But in fact, A&N said, well, we never told them there was a repayment schedule. So that evidence was consistent with my client's testimony. It was E&M who said, well, we had a really complex and detailed repayment schedule. So the absence of that evidence should have been held against E&M. And finally, the Superior Court found, well, hey, there was no communication. Hey, Eslam, you owe us a bunch of money and you need to repay it. And no communication from my client to his saying you need to repay the money. Since the burden of proof was on E&M, it was far more significant that there was no communication from E&M to A&N saying, hey, I just want to confirm that I'll be in tomorrow to drop off a repayment, or I just want to confirm that yesterday I gave you the final payment on the $40,000 loan.
Is the burden at all interrelated to the fact that the plaintiffs are alleging that they've been wrongfully, that monies that should have been paid were wrongfully withheld, and it was your client's explanation that it was because of this loan agreement monies that had not been repaid?
Right, so the plaintiff always alleged these 6 categories of underpayments. And in discovery, we produced a big analysis that was admitted in a certain series of exhibits, I think in the 300 range, that showed our conclusions. And we generally agreed there were underpayments. We disagreed with the amounts. And again, we're not contesting any of that. But the reason this case went to trial is that my client said, hey, you know, we may have owed him some money, but all this time there were these unpaid loans. And if you look at the balance, which is Exhibit 323, it's a big spreadsheet. There's got a column of the running balance, and it was in favor of A&N. Right up until the very end of the parties' relationship, they owed us money until we withheld the payouts for the rides after July 11th.
Well, why is that then on the other side to bear the burden of showing how much was paid if your client is saying this justifies what we've done?
Yeah, well, because under the analysis, it was technically a counterclaim for the loan repayment. So they claimed underpayments. Our defense to that was, okay, you still owed us money. But on the counterclaims itself, we said you owe us the money, and they've got to prove repayment. And they said we repaid the loans. It wasn't like they said, no, you go ahead and prove repayment. They said, We repaid the loans. And here's where the district court actually erred in its evaluation of the evidence. Because it wasn't like E&M just said, oh, I repaid the loans in one lump sum. I mean, it gave very detailed testimony about the repayment schedule. It was 23 payments over a period of 2 years of $170,000. Now, that's a lot of conduct spread over a long period of time for a lot of money. And it's reasonable to expect, well, where's the documentation of that? And in fact, there was none.
But are you saying it's impossible that the court was not entitled to accept just testimony from E&M that these payments were made?
Yeah, that's correct, Your Honor.
Then why was the court required to accept testimony and an allegation that there was a loan extended in the first place?
Well, it wasn't required to accept that, but the parties agreed on that, so it was undisputed. We're not saying that the court can't accept certain testimony. We're just saying that the court's evaluation here was not based on the entire evidence. It wasn't reasonable. Because given the complexity of the payment schedule, one would have expected some sort of records. Canceled checks, electronic fund transfers, notes, emails, eyewitness accounts of him handing over cash. There was nothing like that. And the utter lack of evidence was particularly implausible here.
But utter lack, that discounts that there was testimony.
Well, there was testimony. The utter lack of corroborating documentary evidence.
But what's your best case to suggest that there must be corroborating evidence?
Well, there are cases related to repayment offenses that say there has to be affirmative evidence, and that the Singh case lays this out. And those cases strongly suggest that in a repayment case, you can't just rely on somebody's say-so that they repaid the money, because you'd expect there to be some documentary proof, and so there should be something over and above that.
But don't you agree, counsel, in this case, the parties behave in a manner that was not typical of most business transactions, especially loans within businesses?
Well, I guess I would agree that it's atypical, but I'm not sure about the significance of that, Your Honor, because I think the legal standards are the same.
Well, you've just stated that in most cases, with this length of time and this type of transaction, there are going to be some sort of document, some documentation,
Correct.
right?
Yep.
But this is not most cases.
Well, it's not, but a significant fact here is that Eslam, the principal of E&M, before he took out $170,000 from A&M, borrowed $20,000 from his brother. And we submitted the evidence of that. He wrote checks, post-dated checks, and gave them to his brother and said, here's how I'm going to repay you. Cash these when the dates come by. And in the last one, he wrote balance null in the notation. Now, that's a fairly legal thing to do, and it indicates that he knew exactly how to document his loan repayments. But the district court ignored that evidence. Furthermore...
But wasn't there evidence that your client preferred to be paid in cash?
Well, yes, there was, Your Honor, and that's exactly it. Eslam, in fact, testified, his testimony was somewhat stronger. He said our clients required repayments in cash. And he had sort of a corroborating witness of sorts, Hussein al-Sadi of Premier Trans, who came in and said, oh yeah, I also repaid loans in cash. But those witnesses differed on the issue of requirements. Eslam said I was required to repay in cash, and Hussam never testified that. He said they just wanted their money in cash, okay? So there's a disagreement on whether it was required.
You suggested that it's relevant that he had a different loan with his brother that he did differently, but you don't disagree that your clients did not have loan documentation that we would usually expect people to have if, however people structure it. It clearly was structured differently, and we don't know that he had the exact same agreement with his brother. Why would that necessarily lead us to believe that we can't lead to the conclusion that we can't accept the Superior Court's conclusion that this party was more believable than the other? Neither one of them documented the transaction, but we believe this party over the other party.
Well, in the Khalil loan case, there was no documentation of the loan agreement. It was between a brother, it was sort of a cultural thing between two relatives. And here, there's lots of testimony that this was, a cultural thing. They're all Arabs from the Middle East, and this is the way they do business, and they were very close, and so they didn't document it. And all that's fine, but the issue is that we essentially proved the existence of the loan obligation and the requirement that he pay it back because he agreed with that. What wasn't proved was the repayment.
But you didn't really prove it. As you explained to me, there was no dispute that there was a loan.
Correct.
Okay. But there was a dispute as to the terms, the repayment schedule, etc. Agreed?
Yes.
Okay. There was even a dispute as to the amount outstanding or the amount actually borrowed. Would you agree?
That's correct.
Okay. So why wasn't the Superior Court free to make a credibility determination based on the testimony given at that bench trial about what the Superior Court believed occurred. Because regardless of custom, tradition, how this works, this case came down to the court looking at the testimony and making credibility determinations. Would you agree?
I agree with that, Your Honor, but the standard, what the court was required to do was to consider the entire evidence.
And what do you have in this record that shows the court did not do that?
Well, I'll give you another example, because the things I've been talking about, I think, fall into that category. But here's...
Hold on, before you do that. Two people can look at the same information and reach a different conclusion. Would you agree?
Correct.
Okay. So I want you to point to me the conclusive piece of evidence, not evidence that has both sides giving conflicting testimony, that you believe proves your point.
Okay.
Okay.
And this is the point I'm going to make is related to the cash withdrawals. And this is a point that applies both to Eslam Houari's testimony and to Hussam al-Sadi's testimony, because it was essentially the same situation for both. They both claimed they had this complicated repayment schedule, certain amounts, certain times a month. They repaid loans before they got new ones. They repaid it all. And both of them also testified they took the money out of their checking accounts. We had the checking accounts for both parties. We went through them all, cross-examined them, and those things completely undercut, contradicted their testimony. The loans didn't add up.
But Islam also said that he sometimes paid cash and hid the money in the books by representing that it was purchase of a vehicle or otherwise.
Yeah, that's what he said after confronted with the discrepancies in his testimony. He made up excuses why, oh, well, actually, what I said before, there were qualifications. And yeah, I mean, I guess my contention is the district court didn't consider the entire evidence because that evidence totally undercut what they were saying. The loans didn't add up to the right amounts. The withdrawals weren't taken out on the right days. In Hussam al-Sadi's case, he didn't take out any loans at all. In fact, Hussam al-Sadi's withdrawals corroborated what my client said. My client said he made one $5,000 cash payment in November 2014. We put the checking accounts in front of Hussam al-Sadi, no cash withdrawals until November 2014. And then he changed his testimony. He said, well, before I said I took some money out of the bank, now I'm saying I never did that.
But just a minute, we're not talking about a situation where the testimony of Mr. al-Sadi was used to prove a specific business practice of money lending, but rather to corroborate the fact that sometimes money was lent under circumstances that were other than usual practices. I mean, I don't think that testimony was given to say this is exactly how these payments are made.
But the significance of this whole testimony is that Eslam insisted that he repaid the entire amount in cash. I mean, there was no question. He never said I paid most of it in cash or there were some missing payments. So now, I mean, I'm just saying this evidence doesn't support that.
Okay, let me ask you. So Islam and A&M had a close relationship. Outside of their business relationship, they had a close relationship, correct?
Eslam and who?
Eslam and the A&N brothers.
That's correct.
Was that
with Ned Lawabni, not with Abed. He and Abed didn't like each other.
Okay, but nonetheless, Islam spent quite a bit of time with the N brother.
Yes, Ned. Correct, yeah.
A&N. And they, I think, vacationed together. Their families knew each other. Was that the same relationship with Mr. al-Said?
Oh, with Hussam al-Sadi? No, my impression of Eslam's relationship, well, first of all, Ned and Abed did not get along with Hussam al-Sadi at all. He's like an Iago who's been trying to destroy them for a couple of years, and there's a whole other related case and background there, and that's described in the briefs.
So couldn't the court, from the fact that these are different relationships, take some of the testimony of Mr. al-Sadi, believe some of that testimony, disregard other testimony, from the difference in relationships, believe that the loans to Islam could be different in some respects. Similar in the fact that there was not the documentation you would need, but different in other terms because they were close friends, or at least with Ned.
In principle, the Superior Court absolutely could have done that, but not in the way it did it here. Absolutely not on this record. That was an incorrect finding on the entire record. And I see I'm down to 1 minute. I was hoping to reserve time for
All right.
rebuttal.
Good morning, Your Honors. Greg Jones on behalf of the appellee. We also have Don Newman, co-counsel, and Eslam Hawari on behalf of E&M today. May it please the court. In my mind, there are two main things for the courts to keep in mind, a couple of which you've already touched on, although I'm certainly happy to change direction and answer any questions that you have if you would like at any point. First, I do believe that appellant is asking the court to weigh the credibility of assess the credibility of witnesses, weigh the evidence in several respects. Just talked about why Eslam Hawari was not believable in his testimony and in the story that he gave. He talked about why the court shouldn't have believed Hussam. Those are just two examples of ways in which appellant is now asking this court to disregard the trial court's findings on credibility as to those witnesses and to reweigh the evidence and reassess the credibility for itself. The court made some very express findings in this case that relate to credibility. The court, first of all, made it clear that this was an unusual case. It was not it was complex in some ways, but it was not a conventional transaction, certainly not with respect to loans. The court said that it comes down to credibility, his decision, overall and as to many of the specifics. And then he went about specifically saying that he found Eslam to be a credible witness on the things that he accepted and the facts that he found based upon that testimony. With respect to Hussam, a third-party witness, Hussam al-Sadi, Judge Brodman also said he found him to be a credible witness. So that's important because that's a finding that this court, must accept and should accept.
And I think he found him to be a more credible witness.
I think that's with respect to Eslam, but I think with respect to Hussam al-Sadi, if I remember correctly, I believe he specifically said he found him to be a credible witness. Okay. So, and certainly I agree with Your Honor with respect to Eslam, that he did indicate that he believed him to be a more credible witness. Are
there any claims that do not turn on a credibility determination? It seems like the opening brief suggested that some of the claims could have been resolved or should have been resolved without a credibility determination.
I don't believe so. I believe the only basis for appellant stating that is by taking the position, as we heard a little bit of earlier today, that the court didn't have the power to assess credibility and make a determination of facts on the loan repayment. Appellant's theory of the case and that counterclaim is that if you have a loan like this that's undocumented, if the repayment is undocumented, then the defendant, the counter defendant, always will have to lose. The position is you can't prove repayment in cash, even if the court finds that that was the condition of the loan. And so that's the only reason, that's the only basis that I understand appellant's position being that a claim can be decided without credibility. We disagree with that. We don't believe that that's submitted or that's supported by the cases that were cited by appellant. There's as we mentioned in the response brief, there is some dicta and some references to what the judge would have expected to see in the conventional loan case that it was examining. It would have expected to see the defendant, the obligor in that case, to have some evidence of repayment. In this case, Judge Brodman expressly found that that was not the case, that he didn't expect that. Now, he did express some frustration and was realistic about the fact that it made his job more difficult. I don't believe that it's accurate what appellant has, as the position the appellant has taken in the briefs and here, that the decision reflects that Judge Brodman held that against the defendant, A&N only, and didn't hold that against Mr. Awari. It doesn't say that, and there's no reason to believe that. I believe that the opinion, the decision states Judge Brodman's reasoning as to why he made the determinations of fact that he did, and why he made the determinations as to credibility that were essential and underlaid those decisions. So he gave some of the reasons on credibility, but he didn't purport to give all of them, and I don't think he could.
Could you address the argument that Judge Brodman imposed the burden of proof on A&M to establish the existence of loans rather than on Eslam? What's the...
Yes. I don't believe that is accurate, but I also don't believe that we have to get into that fine detail, because I don't think it matters at all, and for a couple of reasons.
Didn't the court's order specifically say it was
Yeah.
It was A&M's burden to show?
Yes, on the counterclaim he said that A&M had a counterclaim for the loans, and that it hadn't met its burden of proving that money was loaned and it wasn't repaid, which makes sense, and I believe that is the law, and I believe that in a situation like this, I don't believe it's an affirmative defense, repayment. I think it's part of the claim itself. But the reason I say that it doesn't matter for two reasons. First of all, we're talking about preponderance of the evidence, 51%, and so it's not a situation where Judge Brodman said, well, it's a tie, and so the tie goes to the party that doesn't have the burden of proof. In fact, in the arguments in both the opening brief and the reply brief, appellant, they complain that Judge Brodman made determinations against it, to reach the conclusion, and that's what happened. So if it's a 51%, and then if the judge found that it had been met, there's the fact that the burden is on the counterclaimant at that point doesn't matter. But more important than that, I believe, is the fact that the first part of the decision, the part that Judge Campbell noted earlier, was the findings on the contract claims itself. Judge Brodman first took up the plaintiff's contract claims and burdens, and found that E&M had met its burden in establishing the 5 separate contract claims, found that it had met its burden of clear and convincing evidence on the fraud, and also met its burden on proving a breach of good faith and fair dealing. The loan repayment issue was integral to those claims, because Judge Brodman had to find that E&M had proved its claim by more than 50%, by 51%. And the reason that I say that it's integral to those claims is there was a dispute that arose because A&N said, after the accounting was done and after it was determined that, yeah, it had shorted E&M on several different items, on each of the items that E&M had claimed from the beginning that it had been shorted on. It said, well, yeah, but you owe us money still on those loans. And the court had asked earlier about whether that it had taken the position, hadn't it taken the position that it had shorted it had made those underpayments because of those loans, and the answer is no. It never did. It never mentioned the loans. There's no reference to them. There's no allusion to them. It shorted them by not telling the truth about and then on the payout reports by doctoring them, and by not informing E&M that it had been paid by access on the missing rides, the 1,388 rides. Those were paid subsequent to the initial reports and never, they were, NM was never paid on them and never informed about them. So those are the primary two. And then the third large damage element was at the end when it just held money because NM would not sign the change in the compensation.
Counsel,
yes.
Let's move to the non-compete portion of the contract. Can you tell us why the court did not err in finding that the 3-year term was too long, and also, well, talk to us about that first.
Your Honor, the difficulty in answering that question is that Judge Brodman made several alternative findings as to why that was not enforceable. He remarked that he wasn't sure that it was even enforceable because of the length of the term. But I don't, the way I read the opinion was that predominantly there were two other predominant reasons, and the one was, in addition to also not proving damages on it, which again was, I believe, tertiary, the one was that he found that there was bad faith in suspending the contract and found that that was a pretext, and that there was bad faith in doing that, and that it was a pretext for forcing E&M to sign a unilateral reduction in the compensation.
Why couldn't A&N suspend E&M?
We contested that it was ever part of the contract. The only basis that it indicated that it could suspend it was part of a manual for drivers that was never signed or never part of the contract. But there was no provision in the contract that says we can unilaterally suspend E&M in our discretion, and for the remainder of the term, which was, I believe, a couple of years at that point plus, we don't have to give you any work. You can't do any work for us, and you can't do any work for others. So the court, there's nothing in the contract that remotely suggests that that's what the parties agreed to. And so that's one thing. Secondly, the court found that there was no basis for suspension because the suspension, the purported pretextual reason was, we're going to now go back and ask for those original trip log sheets that you were supposed to turn in every 2 weeks. And we're talking about 3 years back, 47,000 rides. There were different iterations of policies that said, all right, you need to turn in original trip log sheets. And it was enforced, not enforced over the period. But every 2 weeks, period closes, they're submitted to access, and they move on. If they're turned in, E&M doesn't have them anymore. And if they're not turned in and they're paid, then it's closed and there's no reason for it at that point. A&N didn't even pretend to have some specific ones that they were looking for, didn't say, well, we have these ones, but we don't have those ones. The judge found that was pretextual, and I don't believe, and there was substantial evidence to find that. So the second primary reason is that for the non-compete that the judge found that I think this court has to uphold because it's supported by substantial evidence, was the prior breaches of the contract. So at the point when A&N said, we're going to suspend you and hold the money that's owed to you now, and just basically we'll see how long this takes, and we will do a fraud audit, which never actually happened, the fraud audit. They just asked for information. At that point, there were already the 5 breaches of contract that already existed. The court, at that point, they had all been raised by E&M. The court ultimately upheld each of those, and they're not even contested in this court today that those 5 existed. So the court found them to be material, and of course they are. And they're also, at least a couple of those certainly support the breach of good faith and fair dealing, because in addition to holding the money on the, under pressure of signing the addendum, when they're not given information, when information is concealed for that substantial amount of damages in the contract, that is a breach, and to allow to allow A&N to say, all right, we recognize at this point that we breached the contract in those serious and material ways, and that existed at the time. We still had this power within our contract of complete discretion to keep you from working for us, and at the same time keep you from working for others. So based upon the court's findings that those were prior material breaches, I think that it's finding that the covenant not to compete, to the extent it was otherwise enforceable, didn't apply. And the court found that the suspension, in fact, was a termination under the circumstances, and again, that's supported by the evidence, because at the same time that it, quote, suspended E&M, it sent out an email saying if they show up on the premises, to call the police. I mean, this is, it's completely inconsistent with the idea that we're just going to ask for a few records and we're going to suspend you until then. And they did various other things like poach drivers and tell other subcontractors go and hire their drivers, all on the same day that they supposedly suspended it. And the court rightfully found that was in fact a termination, at least for purposes of the covenant not to compete.
Can we go on to the economic loss rule argument
Yes.
brought up by opposing counsel? Why shouldn't the economic loss rule preclude the tort findings in this case?
For several reasons. First of all, the Flagstaff case does not purport to extend it to the facts of this case or to a fraud case. A fraud case is different. A fraud is a tort, but it's the torts that were alleged in Flagstaff, as I recall, were negligence, professional liability, and they sought extra contractual damages, the consequential damages, et cetera. And the court, in that context, implemented and affirmed the economic loss rule. And there is no case where the courts have said where there's fraud, if there's a contract involved, Arizona no longer will recognize a cause of action. You can't bring a fraud. Okay, that would be the result here. I mean, because that's essentially the argument, is that there was a contract, and so you can't also sue for fraud. Judge Brodman expressly found that E&M had proven the 9 elements of fraud. And the damages, found that the damages that were awarded were not extra contractual. They weren't something that basically conflicted with the parties, the benefit of their bargain, the contract, their expectations. To the contrary, the damages were contract damages, but the individuals, the court found that they had participated in the fraud, and they had committed the fraud by clear and convincing evidence, and there is no contractual remedy with respect to them. And also, there really can't be a claim of fraud if the economic loss rule extends that far to say there are no torts if there's a contract somehow involved. The cases themselves, specifically the Evans case comes to mind that we cited, but those ones don't say that. They say it's a case-by-case basis. You have to look to each of the cases and determine, factually the expectations of the parties and whether the damages that are being sought.
They do suggest that you don't collect the same damages twice. You don't collect the same damages under a fraud theory or a contract theory.
Correct, Your Honor. Judge Brodman very specifically said in his findings, in his ruling, that there will be no double recovery, that the individual defendants, Ned and Abed, are jointly and severally liable for the fraud damages, which I believe was $68 If I'm correct, it's one of the three ones, the doctored payout damages. And so they would be jointly and severally responsible for those. Those aren't added to the total damages, that they're part of them. So under those circumstances, I believe Judge Brodman was correct that holding and that interpretation did not violate the economic loss rule.
Thank you, counsel.
Thank you.
Judge Catani had asked whether there are any claims that aren't dependent upon credibility determinations, and yes, there are two. One is A&N's counterclaim based on the violation of the non-compete provision, and the other is the Superior Court's refusal to grant a remedy for the kickback rides that E&M performed. Let me focus a little bit on the non-compete claim. There were 4 reasons why the district court rejected it. All of them are erroneous, and they're all fundamentally legal determinations that are subject to a de novo standard. So the standard review is lower on those as well. The first was being mistaken about whether it was a post-employment non-compete for 3 years or just during the term of the agreement. The second mistake was the analysis of whether there was a suspension or a termination of the contract. Ned testified that he used the word suspended in an email, and he said he did that deliberately because he wanted to be able to audit E&M.
Does it matter if the court's correct that there were material breaches by A&N?
Well, that wouldn't matter if the court were correct, but that was the third reason the court gave the material breach analysis, and that was completely erroneous, Your Honor. The court found that A&N materially breached the contract on August 22nd, and therefore E&M was excused from competing the very next day. But it's clear that E&M materially breached the contract from the outset. It was providing kickback meals by June 18th, 2015.
But didn't the court consider that and say that that was something that didn't necessarily harm A&N, and they may have been aware of that?
Well, I don't think the court addressed the issue whether that was a material breach or not. I think the court overlooked that. It did on the issue of whether those were damages say that I found that they weren't much in the way of damages. But the lack of damages doesn't mean it's not a material breach, because if you look at the contract, the entire contract is set up so that...
If there are no damages, is it a material breach?
It still can be, Your Honor, because if you look at the contract, A&N was bargaining for honest provision of services. You should look at all the anti-fraud and anti-kickback provisions in that and in the policies. And for sure, the right to suspend was part of the contract, because the contract mentioned the policies and procedures 14 different times. That manual was at the prior employment, the Minnesota company at MISA. Eslam had a copy of it. He was emailed a copy of it. He was set up to train people on it. It was clearly a part of the contract, and it's just disingenuous for him to say they can't suspend me. It was never part of the contract.
Counsel, I gave you an additional about 2 minutes because of the questions that we asked, but thank you very much. We've come to the conclusion of these proceedings. We thank you very much for your arguments. This matter is now taken under advisement, as well as the other matters heard this morning. We will issue a written decision in due course, and we are now at recess. Thank you.